Thank you. So good morning. We'll convene again, and I see that we have both Bernadette and Rachel online. Welcome. So this morning or today is really the catch-up hearing, and it's an opportunity of tidying up a number of loose ends, and we've received a statement from the two of you with regard to what Amy had prepared for the SASM and Mana Whenua chapter. Just before we hand over to you, Rachel and Bernadette, I just wanted to flag that with regard to the identification of areas of significance to Maori, the whole SASM, the national planning standards are quite clear that identifying sites, which is Federated Farmers' preferred position and one that I have a lot of agreement with, can only be given effect to with the approval of the Mana Whenua. And the Hokanui Runanga have indicated that they're not in favour of it. So it's not an option that's actually available to us to give effect to. So unless there's any legal issues relating to that you want to raise, it's probably best if we focus on the other comments that you make in your submission. So that's just where my personal thinking sits, and to pass that on. So I'll hand over to the two of you in terms of what you have for today. Thank you.
Thank you. Thank you for the opportunity to present this morning on the supplementary statement which Bernadette and I have put in responding to Ms Beerin's statement on SASMs. Look, we won't take up too much of your time, but do want to reiterate that throughout the PDP process we have maintained our preferred relief that site mapping be carried out. This relief hasn't changed, and we have presented a legal argument on scope at previous hearings. However, within our statement we have also provided comment on an alternative situation where the cultural values would be incorporated into the plan. So just to be clear, what we're suggesting is that the PDP contains more detail around which cultural values apply to which activities for which consent is sought. From Ms Beerin's analysis, it's clear to us that the thinking on this by Hokanui Runanga already exists. There has already been consideration about which values are relevant for specific activities. And in our view, this thinking must be incorporated into the plan rather than providing a high-level statement that requires assessment against a range of values. The risk with this approach is that they could be cherry-picked at any time with different values from wherever the values are located within the plan, and also that there could be a different way of interpreting which values are applicable per activity with staff members within the council and also within Hokanui Runanga. Our suggestions will help ensure that farmers do not need to use a consultant every time they apply for resource consent, that council officers have certainty on when they need to engage Runanga, and also that when assessing applications, Runanga will have certainty on their processes. So we think that this will save time and resource for all parties involved. I'll just wrap things up by thanking the panel for the opportunities provided to Federated Farmers in terms of being able to provide this further response relative to the SASMs chapter. I appreciate it's been quite a complicated planning process for you and quite a challenging regulatory environment at the moment. So we're happy to take questions on our preferred relief of site mapping or on the approach presented in our statement. However, we have presented our legal arguments and that will be for the panel to consider and make decision on.
Thank you for that. There was some supplementary material that came in last week that provided some feedback in terms of the way that reference was made to cultural values throughout the plan. Is that something you've seen and want to comment on?
No, I haven't seen that, sorry. I was actually on leave last week, so I haven't seen anything new that's come through.
It probably, the comments you've made, I think are relevant to us in terms of the way that we look at that document. I think your key message is specificity rather than general values. So I'll just see if there's any other comments or feedback wanting to come from the panel. Cliff?
In reference to my question of the other day?
No.
No.
Okay. Glenys?
No, I thank you for your submission, and I do understand where you're coming from. Thank you.
Maria?
I also don't have any.
You're not, Mike didn't turn on.
I also don't have any specific questions, but I just do want to say it's helpful to have the written statement for us to work with as we're finalising our decision. So just wanted to thank you for the effort that both of you put into supplying that written statement. Kia ora.
So if there's nothing else, then we'll be handing over to our advisor and just talking a little bit about the additional material that we've got. And if you want to stay online, if there's any issues coming from that, please speak up. I'd like to take the opportunity, however, of thanking both of you for the input that you've had through the process over the last nearly 12 months. There's times where we as a panel have I guess, struggled to keep up with the pace of everything. At times we've become a little bit frustrated, and particularly Bernadette at the last hearing, some of that was channelled your way, so apologise if that kind of took you by surprise and upset you in any way. We're doing our best in terms of the volume of information that we've got to come to grips and full understanding. Please, I just wanted to acknowledge at times we haven't always got it right through this process, but I thank you for the input that you've had.
Thank you.
So in terms of tidying up from the mana whenua values in different parts of the plan, Courtney, you've done a big chunk of work that's looked at in over a very short period of time of the way that we should be looking at all the provisions throughout the plan. Is there anything that you want to add?
The only thing that I'd like to add is just to reinforce the intent of that table was really around consistency. So as you'll appreciate, different people wrote different chapters and different ways of referring to things. So what I've attempted to do as I've gone through is to make sure that when we're talking about the same thing, we're using the same wording so that it's clear that this is the same thing all the way through. Where there's been progress with the runanga around narrowing the scope of those values, making sure that those have all been referred to in the same way. So you're just really around that consistency. There's nothing in this table that was intended to change the effective rules. It's just really about making it nice and nice and clear for everybody to the best of my ability.
Thank you. And noting your comment that the runanga themselves haven't commented on what's here. And I guess when we come to go through the detail, we'll need to be mindful of some of the comments that they've actually said at some of the hearings. And I guess while you're providing us with a consistency, I guess the overriding message from both yourself and from the Hokanui runanga is, I guess, specificity and trying to give some clear direction in terms of what's required. And that's really the message that I picked up from Federated Farmers, that they're wanting that guidance to come through as well. So are there any questions from the panel, Cliff?
Yes, I'll try and frame it. You've heard the submissions, Courtney, the concerns of Federated Farmers and others that there's not enough detail or specificity from mana whenua, and that might disadvantage, in this case, farming activity that would be presently considered, normal permitted day-to-day activity. And the question that has been posed, or the concern out there, is that it may impact or trigger, this lack of specificity may trigger a consenting process that people don't want. Could you respond what the Runanga's approach you expect it to be?
Yeah, first of all, to clarify, I can't comment on what the Runanga might be thinking, but I can comment on, from my role here for council, what my perspective is. I think it's important for us to reflect back on one of those earlier tables where we set out where that consideration of various Ngāi cultural values would actually trigger a consent. And it's not in as many places as I think there's a perception that there might be. I think that there's a lot of concern around something that's actually not going to impact things too much on the day-to-day. And I have sympathy for that, because it's a change in the way we're doing things, and of course that's going to create some nervousness. But I don't think it's going to be as impactful as it has. To add to that as well, though, I think that, from my perspective, we talk about wanting more specificity, but the impacts of different activities on different locations, it's a very fluid thing. So it's hard to front end that specificity without knowing all the details of what someone's actually doing. And from what I've seen through the work, the amendments that the Runanga's put through, and the conversations that they've been having with federated farmers that I've been privy to, which isn't all of them, to be clear, I think it's been a process of trying to put as much specificity as possible without knowing all the details of the individual thing that everybody's doing. So it appears to me that there's been a genuine attempt to find that sweet spot between specificity in the front end and providing that flexibility to make sure that the decisions that are made are based on what's actually happening on the ground. Because the previous way things were done, sometimes that would mean that there was restrictions put on to protect Ngāi Tahu cultural values when actually they didn't need to be, because of trying to front end everything. So it's important to think of both ways. Yeah. Anything that, good.
Well, it's just a comment, Courtney. I'm just thinking it's not too different to the operative plan, really, because we did have to consult on these issues that are in the activities now. So
this approach in some places makes it more narrow than the operative plan, so there's less restriction than the operative plan in some perspectives, or in some instances, sorry.
And picking up your point about the previous table where that analysis was done around whether cultural values were a trigger or whether they were a matter of discretion, and I remember our conversation was that by and large it's not a matter of being a trigger, it's more once you've entered the need for a consent, that's where consideration comes in. And so I just wanted to check that we were talking about the same table when you, at the outset, you're talking about Appendix D that was attached to the latest, and that and what I pick up from Appendix D is that you are drawing from all of the evidence we've already received, and I take your point that it's primarily around continuity of language, so
E is what I'm looking at, not D.
oh, well that's why I was asking, to make sure I was looking at the right thing. Oh, yes, I've got the open document in front of me, but it's labelled as Appendix E electronically. Okay, this is helpful for us for later when we're going to look for things, so thank you.
It's this one.
And I do note that XX in 31 pages comes up 291 times. So while it's a tremendous amount of work for you to have written it 291 times, just bearing in mind that the panel will also be having to go through it 291 times.
If I knew which of those options you were going with, I would have put it in there for you.
Okay, anything else from you, Maria?
No, I just think it's been really helpful, the amount of effort that's gone in on all sides to get us to this point and assist us with our final decision. So I just want to acknowledge that. And I know Runanga representatives aren't here to hear this, can't see everybody online, but just, you know, all parties involved and the fact that there has been that collaboration going on behind the scenes has definitely assisted us at this end of the process. So, kia ora.
And in terms of my notes, collaboration is one of the words that I've got here, that the efforts that you've put in on that basis have been extremely helpful to us. And in much the same way as Federated Farmers, in terms of looking at all issues that arise from the submissions, we've had to put you under the pump, not only to ensure that we are looking at all options, but also to appear that we're also looking at all options. And the way that you've responded to us is helpful at the end of the day. So thank you for your input to it, and enjoy a little bit of quiet time for the next little while going forward. So if there's nothing else, we'll let you go and spend an hour and a half doing something else before you have to go back to the junior school.
We all just want what's best for this community, and we're just doing what we think is right to get that. So I think that's what binds everyone in this process. No matter what angle we're coming in on, we're all doing it because we want what's best for this community, and I think that's really special.
It's a bit like sitting the last exam of a whole lot of exams at university, knowing that you can unwind for a while until something else comes up. So thank you. Marcus, please join us again, and we'll hand over to Mishka and Shelley to really, in their own style, to respond to a host of things that came up this morning.
Mishka and Brett, are you ready? They probably thought it was going to take a bit longer. Yeah.
Sorry, sounds only just clicked on. Did someone have a question for us? Or?
No, just checking that you're all good. So we've dealt with SESM super promptly. So just want to move back on to the topics we were discussing this morning.
And sorry to interrupt, but I forgot to acknowledge that Brett is online too, so welcome, Brett. And I guess we're in the hands of you as a team in terms of giving us the advice you wish to pass on. Thank you.
So I have, as a legal issue, some comments in relation to a deferred date for rules to take effect. As I understand it, that's something that I might have missed to address in written submission, so apologies firstly for that. It's a little difficult to address out of context, particularly because deferral in relation to activity status, on my understanding, would be very difficult, including because, for example, there are specific requirements for controlled activities and restricted discretionary activities in 77B of that, but I'd have to come back to you with those specific references. There's also case law relevant to framework and development plans, which I would need to review in detail if that was where that was heading, but I don't think that's quite as pertinent on this topic. In terms of deferred date for rules, I just want to clarify, it's not that they would take legal effect at a later date, it's that they would apply subject to conditions. So their legal effect would still need to take effect through Section 86B, which is when the rule comes, or the plan provision becomes operative because it's, say, no longer subject to appeal, but its actual application might be deferred as a result of compliance with specific conditions, perhaps. So the general comment I would have about that is that you can put conditions on the operation of a rule which align generally with the types of conditions you might see on a resource consent through Section 108. So they would need to be very clearly drafted, because I have seen a number of instances where rules are conditional on things and unintended consequences have meant that they don't then take effect when they were supposed to, or be applicable when they were supposed to. So with apologies for how general and a little bit imprecise that submission is, I hope it's given you some guidance on where the crunchy points are for deferring application of provisions, and happy to look at it further in the context of a specific scenario if that might be able to illustrate the submission better.
Because yeah, that was a good start, thank you. What I was looking at was 86B1C, where it says the council resolves a rule has legal effect once the proposed plan becomes operative.
But
And in the context of what we're talking about with the natural hazards.
and my understanding of that provision is that applies to council as opposed to the hearing panel. So I would need to go back and consider that whether or not it could apply to the hearing panel. I have always, where that provision's arisen in my previous work, it's applied where a council has made that resolution in the course of notification or those sorts of decisions, as opposed to in the context of the Schedule 1 process.
Well, I think we'll talk that through and come back to you if we need further clarification. Thank you.
So the other legal point, which I think is closely tied with what Ms Ben-Heedy and Mr Osborne can talk about, is the significance risk definition. So I'll just chip in my little comment initially, which is the point around scope of a submission versus the application of the RPS. So for me, the scope of a submission provides the panel with the ability to make changes to the notified plan in a certain manner. So if a submission specifically said insert significant risk definition, then there's clearly scope in that submission. So that's your ability to change the notified plan. And then you have those sort of echoes of imprecision where scope needs to be foreseeable based on the wording of the submission. The role of the RPS is certainly important, and it guides your development of the plan and your development of the provisions, but for me it doesn't provide scope by itself, for the reason that someone is picking up a submission to see what might happen through the Schedule 1 process. They're not picking up the RPS to do that, they're picking it up to guide the development of the plan. So that's my submission on that. I did just want to briefly engage with scope. I know the panel's had a lot from, probably a bit sick of scope issues from me, apologies, but I just want to highlight in terms of the mapping, we haven't had mapping, the points of the process where there has been no mapping. So there was no mapping before notification, there was no mapping in the submission, there was no mapping at hearing 1. Mr Roy certainly attended, Environment Southland certainly attended, but there was no mapping then. There was also no mapping in our specific zone hearings. So illustrating how mapping might play out for a residential development was not something that Environment Southland could do at that hearing because the mapping was not available. So the discussion and the interrogation of how that would fall out for particular property owners couldn't be had, say, as between the 0.5 AEP rule versus mapping. That couldn't be interrogated in any of the zone hearings because that topic didn't come up. So again, for me, that goes to those echoes of scope, because it's how much it puts people on notice that this is a potential alternative option or an alternative mechanism for addressing this issue.
Can we just talk about that before we move on? And I've got one question, and I know Councillor Bartlett has another issue. And during the early hearings, we were reliant on the reports that came from Tonkin and Taylor, which information was available at those hearings. And so I think the issue only relates to what is now shown on the maps that have been presented in the last month. So for Mandeville, for Pukerel and other areas, I don't think we've got an issue. And it's only when we come to the townships of Gore and Mataura and the way that information is used. From my point of view, what I'm understanding is that we have lines shown on the maps as notified, and we can't change those lines. But in determining what is significant, and I guess it comes back to that issue, in determining what is significant, then even the earlier reports from Tonkin and Taylor talked about the 6 classes of risk. So the concept has been there, and my understanding is that what we're now showing on those maps is information we should be having regard to as to the way that we deal with rules within the areas shown as notified. And I guess what I'm looking at is that, for example, we have the areas subject to protection from the flood banks, which is the central area of Gore. Are there any scope issues in terms of the way that rules are applied in that area?
We did look at that at the natural hazard hearing specifically, but where I have always thought about those sort of, you've got the clear scope given in submissions for change, and then you've got the echoes. So yes, you can draw upon the summary of submissions, you can draw upon evidence, and you can draw upon evidence given orally at hearing to provide a basis for considering alternative options. But your ability, the grey area, you have a much weaker standing to shift into those greyer areas when you're solely relying on evidence as opposed to submissions or notified provisions. I wonder if, and this is addressed in the Minute 43 response, so I wonder if perhaps I can hand over to the planning team to look at that and where they've seen that hazard classification addressed, and then we can come back to it. Would that be helpful?
I think Maria's question first.
I've got one question beforehand, and it's because I've been burrowing around in all of the legal submissions we've had on scope leading into this hearing, and one thing that I found that there was some common agreement across legal submissions, not just from yourself, was the idea of vertical integration, and if we accept change at the objective level or the policy level, then we need to ensure that things line up in the lower order. So you're nodding, so I'm on the right track. So and just before we took the break, I had a look again at the Environment Southland submission, and it's very clearly got concepts of significant risk to give effect to the RPS, avoid in areas of significant risk and manage in other areas, and then drops that down into directions in the policies, and splits out sensitive and non-sensitive activities. So that basic frame and those basic concepts are present through the Environment Southland submission. So the fact that you nodded before indicated to me that if we accept some of that at the objective and policy level, we're going to then somehow have to work out how to achieve that in the rules.
And I think so coming at it from that point of view, I totally agree with that. principle of approach, but then I also would urge you to come at it from a base point of view, which is where the rules the rubber hits the road, really, in terms of the rules, and to consider the impacts on private property and private rights, what a property owner would see as being a considerable shift in their ability to do or not do something. So while I 100% agree with that principle that comes down from that top, I also would urge you, and this is where I think the mapping submission in particular comes from, to look at it from the lens of bottom-ups as well, because the change, for example, that's why an activity classification is treated more seriously than a word change in a rule. So you add an extra classification into a rule to capture an additional type of an activity, less impactful for your average property owner than a whole activity classification change. So and also, you know, like an activity classification change where it becomes more permissible, again, probably going to be less contentious for a private person. So I would urge you to take this principle, but observe where it interacts it from that bottom-up approach, and that's where my submissions on mapping in particular have been stronger. So it's turning your mind, and this is why scope issues do very much come in to play when you're considering a specific scenario, because you're then playing out how they work for members of the public across the board, because there's members of the public in town, there's the rural sector, so how those apply and the impacts on them in a private property sense are different across the board. So it has to play out in terms of, okay, how has that person lost their opportunity to participate and engage with the impacts on them.
So if we didn't accept the points on the objectives and policies that Environment Southland have made, then we would be knowingly making a decision that did not give effect to the RPS. So is it our job, in light of the Environment Southland position, to determine how best to achieve that at this point? Like we can't, it's not really available to us with the information we have now to ignore that in any way. We have to find the solution that gives effect to the RPS in response to the submission, whilst being mindful of the level of change or impact that you've highlighted.
Thank you, and I hadn't noted this down to comment on, but I did want to say something about it. I don't agree with the proposal not to make a decision on the natural, I don't know, you may not be engaging with it substantially, but don't agree with that option, because you are then not addressing your obligations in terms of natural hazards and putting provisions in the plan on that topic. What you have to draw a line on is when you had the information which provided due process to be followed. So while I accept there is new information, which we all would like to have before the plan was even notified, you are bound by the process that commenced on a couple of years ago. So the information as it was at notification plus submissions really is your line that you have to draw for you to then do your best job of applying the Act and the regional policy. And that's what the team has put together, is the best job, having drawn the line as at that submission point. And that's what I've urged you to be aware of through submissions, accepting there's those little grey ripples where you sort of can bring a few things in with the new information, but because of the obligations of the process, you have to draw a line in my submission at the point where the framework fits best with what you had at that point, keeping in mind the community couldn't engage with anything else.
So something we're really mindful of in our decision came up prior to the break and discussion with Federated Farmers, etc., was that the information that's now available is already having an impact at the property level on LIMS. So if we make there is potential that our decision becomes out of step with what is already the reality for property owners. So does that have a bearing and change the nature of our considerations compared to some other kind of situation that wasn't natural hazards and didn't impact limbs in the way that this does?
In my submission, you are bound by this process. LIMS and PIMS are the information's added to those through a different process, so that information follows through based on that process. Equally, the application of the 0.5 AEP rule gets applied through that process where people go straight to Environment Southland. Just because those aspects sit there outside this process, I don't see them as guiding this process in terms of scope. They are separate from this process, but can, for example, in relation to that 0.5 rule, give you some comfort that that information will be brought through by the application of that rule. So you are able to draw confidence that the flexibility that was inherently provided in that rule is able to give council the tools to bring some of that in. Obviously not in a perfect way, because the framework of your ability to work up a perfect framework has not been provided through this process. No one wanted that, but that's where we are, and you can only do the best you can in the current process, would be my submission.
Okay, but we still have a responsibility where there is awareness of significant risk to avoid in that circumstance and not just manage.
But your handrails must sit based on the information provided at the outset of the process, and where those handrails sit, you may need to identify them and say, we are bound by this process to stay in our lane. That's a regret for us for X, Y, Z reasons, and that is why we're recommending something else.
And so that would be, based on the questioning that Commissioner Havell had before, would be the notified planning maps and the Tonkin and Taylor advice.
And that's where I wanted to hand over to Mr Osborne and Ms Banhidi to work up how they thought that grey area, where those tools could really fit in that grey area. And my understanding is they've done the absolute best they can to work that through, and it reflects best practice, and other councils who have found themselves in similar situations in terms of information provision.
One further thing before we hand over, and worth exploring now. So you're comfortable from what you've described with a rule that says 0.5, you've got to go to Environment Southland to find out whether you're non-complying or discretionary?
So for me, it is a fixed piece of information which is able to be verified, but equally also able to be argued about through a consent process, and then the consent process provides the ability to find the right answer there. So someone could apply for the wrong thing, and through the consent process they would then find actually they're discretionary. So the consent process is available to interrogate that issue and provide, even if someone's right on the cusp, that will be interrogated and able to be managed through the consent process.
There are some circumstances though where if you comply with the 0.5%, you're a permitted activity. So isn't Environment Southland then dictating what's permitted and what requires a consent?
Then a landowner would, if they disagreed with Environment Southland's interpretation, a landowner has the ability to lodge an objection through those processes, or alternatively.
So I'm just focusing on, so you're permitted provided the floor level's a certain height, and Environment Southland will dictate that, and if you're not, then you need a consent. There's no opportunity to object to the information that comes from Environment Southland.
No, but the resource consent processes, sorry, I shouldn't have said objection. The resource consent processes and the framework around it, including declarations, or the engagement with Environment Southland gives one level of information. Someone might have the ability to then seek their own information to challenge that. But yes, there is a line, but it is predictable and it does require expert input.
Right. And I think the response to what I see as an issue, a building consent will come in and the building department will say you need a resource consent, and there's a procedure if you don't agree with that. So, thank you. That
And I think the Building Act has to stand somewhat outside. While we all know that it's definitely something that you need to, a process you need to go through for a development, it does need to sit somewhat outside your consideration. It's not a mechanism that you necessarily take account of as giving you the correct approach in this context.
if there's no further legal.
I do have just one
Yep.
question. Just legally, I'm just unsure about this, but Mr. Roy has in previous hearings brought up the fact that there is mapping happening orally, and anybody that was listening to that could inquire about that. Does that not give you some scope as well to bring in maybe the mapping?
So just dealing firstly with your question to Mr. Roy this morning, in terms of the availability of mapping, Environment Southland has indicated July. There's nothing to give any certainty that would happen in July. There's no way in the plan that could be done. There's no way that anyone could force Environment Southland to do that. And Environment Southland has its own processes, including political processes, which could easily alter the date that was available. In terms of him saying that mapping would be available in the hearing, the point that I've tried to labour is that if it's not available in a submission or in the paperwork that has been provided through the plan process, it makes it very difficult for someone else to come along and say, here's my property, it's in a red bit, what does that mean? I'm not happy with you calling it a red bit, I want you to stop this process as it applies to me. So that is in essence what is expected through the Schedule 1 process, is that everyone who's worried about not being able to build a house on their land should be able to come and tell the council they don't agree, the reasons why they don't agree, and if they want, to bring their own experts to challenge Environment Southland's modelling. So yes, he said it, but I'm a lawyer, so I'm looking for certainty and I need it to be written down somewhere. And I can't see anywhere that it's written down, which gives people notice but also gives the councils, all of them, certainty that it would happen.
Okay, we'll move on.
So did you guys plan to go through the minute 43 response, or do you want to jump straight to the significant risk issue and around how those hazard classifications fit into that, or what would you like to do?
Happy to take the minute response as read and just dive straight into questions if that's what the panel would like to do. Or brief.
Probably not that simple. Given that we have so much information thrown at us on a whole host of topics, really need you to give us an overview in terms of your response to 43 to trigger a few things. Thank you.
Sure. So this was a bit of a team effort. Brett initially did a lot of the background work for this, but it was unavailable last week, so I pulled it together along with the expert conferencing with Marcus and Laura's involvement. So I guess a high-level summary is that Brett and I both got to the view that we don't believe there's scope to incorporate significant risk as a definition, but then more importantly, how that definition then filters through the chapter. So that's laid out within the reasons, and scope is one of them. But just aside from scope, an issue was raised that there's just not really the time in this process to thoughtfully incorporate that significant risk definition into the chapter without creating some unintended consequences. Plan crafting takes a lot of time, and there just wasn't enough to be able to do that carefully within this process. Putting all of that aside, we did conference with Marcus and come up with largely agreed definition of significant risk. You've heard Marcus talk about the 1% and his views on that. In my view, the 0.5% is more appropriate. It aligns with our expert evidence in
challenging that 0.5%, so it hasn't had too much further scrutiny through the process. I know Brett might have some thoughts in terms of wider district plans throughout the country and consistency with that, as well as some discussions with Tonkin and Taylor around the 0.5. And then in terms of how that could be integrated with the district plan, there was the significant risk and other, and then there was also the differentiating between sensitive activity and non-sensitive activities. So in terms of that significant risk definition, because of the spatial extent of the ES flood modelling, it means that those areas outside of the ES flood modelling, there's a bit of a gap of information of whether or not they would be determined to be significant risk. So that would either require plan users to go and undertake site-specific flood investigations to see whether they fit in that or not, or be assumed to be significant risk. So there's some big implications of how that then applies in terms of further regulation in those actual potential inundation areas that aren't covered by the ES flood modelling. And then sensitive activities versus non-sensitive activities, that was the other matter of departure from with me and Mr. Roy's views. So Mr. Roy might want to expand again on his views of how the RPS interprets that. My view is that the policy is less absolute and there's room to incorporate expert evidence, which would rely on Tonkin and Taylor, who have suggested, you know, in terms of like Lynn, there's a big difference between sensitive and non-sensitive activities. So it's our recommendation that if the panel were to incorporate the significant, non-significant aspects throughout the plan, that you would differentiate between sensitive and non-sensitive activities. And it just means you're able to enable for a bit more without risk to human life. I guess that was a general overview of the minute response. Brett, did you want to pipe in?
Yeah, sure. No, I can jump in there. Look, I mean, I think firstly I just want to acknowledge the difficult position that the panel finds himself in at this point in time. I mean, there's a lot of information that's come in right at the very end of a process, and it's put you in a difficult position in terms of trying to reach an appropriate outcome. And I think we've tried to work through that as best we can in terms of setting that out in response to Minute 43. So it's attempting to recognise that there is better information available, but it's not complete. It doesn't cover the entire known floodable area. Yet the amount of changes and the implications of trying to insert that into the plan at this point or this juncture of the process is subverting a normal Schedule 1 process. And I think that's the challenge here, is really trying to take it through the normal robust course that all submitters and all potentially affected parties would have an ability to consider, comment and respond to as part of working towards a robust decision in a chapter that can capture that appropriately. The issues that we've set out within the response to Minute 43, firstly turn their mind to that sequence of questions. So turning its mind to significant risk, is it possible to craft a current best practice version of that definition? Yes, it is. We've presented one in there. That lines up with recent examples within South Island, and in particular Timaru's proposed district plan that's out there at the moment and also going through a hearing process. But it also reflects other similar definitions that councils have adopted and are in the process of going through proposed district plans. What it does is it reaches to that hazard categorisation, which also in turn reflects the categorisation used on the maps that Environment Southland have presented. The problem that that creates is that that's fine to the extent of the ES model, but it leaves
Can I just, before you move off, just pick that up for a moment, because I think what we do know is that the Tonkin and Taylor advice has been visible through the hearing process, and while we take the expert advice that what's contained there should not be incorporated in the plan as planning maps, nevertheless, that Tonkin and Taylor advice does incorporate the hazard classifications, and therefore is available information outside of this new modelled, better detailed information, that provides quite a substantial signal to someone wanting to know whether they are in an area of significant risk or not. It's a signal. It's not complete information. It's not. We know that it's not complete because further work is being done, but it is available to a plan user who might need to apply that definition of significant risk without the planning maps being incorporated, of course, just within the notified inundation area. That would be the trigger for a rule framework.
Yeah, well, best practice would be when a plan user comes to a plan to clearly find within that document itself where they sit in terms of their site, any potential overlays, and arrive at an activity status, so it is quite clear to them. This approach...
Can I ask then, the overlay exists, so that's one thing. If the definition is clear, what we've heard from legal counsel is that a resource consent process can help tease out the basis of information for determining activity classification at that point. And so that at that point would use all the information available to test the definition of significant risk, which is fixed, and make the determination of activity classification. So that's the advice we've just received from legal counsel, and in that respect it wouldn't be dependent on a map so much as dependent on the specificity and objectivity of a very clear and workable definition. Is that a sound way to think about it?
So the approach would be that an applicant sitting outside the ES model area would need to go engage third-party advice to determine whether or not they were meeting that definition.
If they were in the overlay, the inundation risk overlay, they would enter the rule framework there.
It would also come up where there's a subdivision consent for areas outside, because the policy framework for subdivision requires regard to be given to natural hazards, and section 106 would also apply, that the council can't approve a subdivision if depending on the natural hazards as well.
But in this plan at the moment, we're relying on the overlay of potential inundation to be the trigger and the signal for understanding where further consideration of natural hazards is needed. So we're not, in other words, we're not absent of a map, we've just got a map that's functioning as a trigger, that if it was used in conjunction with a very clear significant risk definition, and we know that information is available which may be imperfect but is present, that would be a good starting place for someone working through a resource consent process. So in other words, they could go further and seek more in-depth information in relation to their particular site, or they might design based on what they can see, knowing that it's imperfect, and that those options would be the kind of options that would ordinarily be teased out through a resource consenting process.
Sorry, are you asking, do you want me to respond to
I'm just waiting to see, like I was expecting you to interject if you disagreed with anything that I just said, or give me a different characterisation, but I'm letting you know that that's how I've understood what Legal Counsel have said, partially taking into account that bringing in either the Tonkin and Taylor maps or the ES maps is not an option. The legal advice to us, aside from what we've got from Environment Southland, is clearly pointing towards that being out of scope. So that if we accept that position, what I'm trying to explore is the extent to which we can lean into significant risk and a very clear definition of significant risk. And my reason, my reason for doing this is pretty fundamental, and it's that the challenge that was laid down by Environment South and I don't see has been addressed. So probably the next question I want to ask is how in the recommendations, your final recommendations that you've given us, are we confident that new development in areas of significant risk will be avoided?
Are you applying that approach completely in terms of the request of minute 43? So when I say that, I'm referring to the diagram 1, which was included in our response to minute 43. For example, on page 3, diagram 1.
I think you've done a very good job of teasing out what that could look like, yes.
So in saying that then, for example, in those outlying areas, the actual potential inundation area being the trigger overlay for applying significant and sensitive would be a policy direction of the void and a non-complying activity status?
No, I'm suggesting a bit of nuance to that. So the overlay is the trigger in combination with the definition that you've offered up, which is agreed upon, and I understand that you're not offering it up in your recommendations, but you've at least got an agreed understanding of what significant risk is in relation to best practice, and you've provided us with that definition. What I'm interested in is the combination of the overlay with that definition, and that would then you would do the same exercise as what you've done in that diagram, but with the combination of those two things.
Sorry, Brett, can you keep that answer and ready to answer that? But can I just also observe that the significant risk definition is only for the areas where Environment Southland flood modelling is available. The definition doesn't refer to Tonkin and Taylor, and I would start being concerned if it did refer to Tonkin and Taylor, because then we are in a position where we have a fixed map, and it actually also raises for me a question around the panel being able to develop rules with certainty of the information before it. So you have the information and you know how the rules operate is the general sort of direction that you must always follow. In this case, we're working with muddy information and we don't know if you have it or not, particularly outside the Environment Southland modelling areas. So my observation firstly in response to that would be the definition only talks about Environment Southland modelling. We know that that's not complete. And if we are starting to refer to some Tonkin and Taylor modelling, again, have some concerns about that forming part of a plan provision.
So when I look at the significant risk definition that's been offered to us, I guess I wasn't necessarily relying on the environment flood modelling alone. I was reading that note as a note and thinking of it as a note. But the operative elements of the significant risk definition are the 3 bullet points in the chapeau. So those, from what I understand from the evidence given to us, are based on the hazard classifications framework that was common to Tonkin and Taylor advice and the latest ES modelling, and is expected, based on the expert evidence that we've had, to be the basis for all further modelling that occurs over the life of this plan, because it is best practice. So in some respects, what you've provided here in the significant risk definition, in my mind, is sitting independent of whichever report applies that has a classification. And at the moment, we've got two. We've got the Tonkin and Taylor one that's used that has a classification, and we've got the ES one, and they're of different standards and qualities, but they rely on that same differentiation. So I wouldn't expect from the advice that we've had to date that anything other than the note, that is fixed and could be relied upon for the life of the plan.
The note, though, isn't true across the whole district.
No. So
And
it's separate.
the Tonkin and Taylor reports only give us the second bullet point based on what some have described as some more historic information. So I guess where I've got uncertainty is we've been given a definition, but I think the advice we've been given is that we can't incorporate it in the plan covering the whole district. And if we can't have it across the whole district, then maybe we shouldn't have it for the areas that are shown as flood prone for part of Gore and Mataura.
But also, just to be able to incorporate it properly, we'd almost have to be going back to square one, and that's my understanding of your guys' response. So I should really let you talk, Brett, sorry.
I guess what I'm trying to get at is if we don't have this definition of significant risk, my question to both of you stands as it was before, which is how do we know, based on the recommendations that you have given us, that we will avoid, in our decision, new development in areas of significant risk? That's my primary question in all of this examination.
Yeah, and so the recommendation as it stands within the 42A and to my supplementary evidence is that balanced approach. It's using the information that was available through the whole process, available, to all submitters up to this point. And it takes a balanced approach where it's using those three overlays. And within the actual and potential overlay, it treats that in relation to the RPS as the higher hazard area. So it takes that avoid unless approach. And I know you take a slightly different interpretation of policy NH5 from the RPS, but there is, I think, the RPS itself is sufficiently broad that it seems most parties involved in this conversation can take a different view depending on where their perspective is coming from. So from mine, I've taken it as in relation to the guidance note underneath it, and I've taken reference to whether it is protected or not. These areas that are protected are considered within that guidance to be less susceptible or less at risk, hence the stop bank protection area being a differentiated overlay, whereas the actual and potential has experienced flooding in the past and it is unprotected. So it represents, it is distinguished from those protected areas. Now we've heard from Mr. Roy that that level of protection is much lower than anticipated, and I'm not sure that any further works are proposed to increase the stop bank protection, event level protection. So we're left with how do those areas get protected and what development occurs in there. So the changes that I've recommended based through the course of the submissions within the boundaries of those submissions, which relate specifically to Environment Southland submission, is Policy 2 and Policy 3, and I've stepped through that in my 42A around page 34 of my 42A. And it turns its mind to whether we are managing effect or within the actual and potential inundation area, whether we should avoid unless there are exceptional circumstances. It doesn't have the information as part of going to the core of whether it is a very, very high risk or not. It just doesn't have that, but that will come down to a site-specific analysis. But it does, through the policies, seek to avoid experiencing hazard effects, and that is one of the changes that I've recommended to policy 3. That then maps into provisions for policy, for rule, 6, and sorry I don't have it immediately in front of me at the moment, so I'm going from memory. But rule 6 within the actual and potential inundation area then considers whether it is an extension to a sensitive activity or whether it is a sensitive activity itself, and it depends, the activity status depends on that basis. So when you get to that point and you're in that area, that provides, certainly from a plan user perspective, what course or which activity status you would fall under and what your reaction would be to that.
So lots of this to and fro really does come back to how we, well, one core critical part of it is how we think about that stop bank protection area with the information that we've got now. And if we understand that minimum floor levels are a managed response, not an avoid response, and if we also know that within that stop bank protection area we do have a mixture of significant risk areas based on the ES modelling and lower risk areas, so a bit of a mixture. Would the precautionary approach say that we should in fact be avoiding new development of sensitive activities in there regardless of the management, but the potential management response of minimum floor levels?
Sorry, you were breaking up a little bit there, so I think I might have missed the essence of that question.
Okay.
I don't know, did you capture it, Michelle?
No, sorry, I'm struggling too. In what areas were you thinking?
So within the stop bank protection area, we know from the modelling that there is a mixture of significant risk and lower risk. If we use the hazard classifications, there's a mixture in there. If minimum floor levels is a managed response, not an avoid response, and if we can't utilise the most recent mapping in any way in this plan, but we know it exists, would the precautionary response to that be in the stop bank protection area that we should move towards the avoid response until such time as the more detailed information comes through a plan change? Would that be the more precautionary approach at this point?
Yeah. So yes, if I went back to diagram 1, that's how that would follow through, effectively imposing a significant risk, a sensitive activity, as soon as you were over that category H3, so if you were H4, H5 or H6, then the rule framework would follow through, that it would be an avoid policy and a non-complying activity status.
So if we can't use the maps that provide that hazard classification that we all understand now quite well, if we can't use that because the notified version only had this flat inundation area, but we also know that within that flat inundation area there is a mixture of significant risk and lower risk, is the precautionary response for us to treat the entirety of that inundation area as if it were significant risk to avoid new development until such time as there is a variation or a plan change to bring in the more refined information?
Sorry, so that was that's the same theme's question in a different overlay?
No, it was the same overlay. I'm just going to stop now, but you can understand there's a little bit of cross wires happening here, because your answer to me used the hazard activity classifications in your answer, which is also the significant risk definition, right? But if we accept all of the advice that's coming from legal counsel and yourselves that we cannot use that significant risk definition, we cannot use the hazard classifications, even though we've got the Tonkin and Taylor maps and all that expert evidence, and even though we've got the very detailed ES modelling. If we can't use any of that, but we know that there are areas, because of that information, we know that there are areas of significant risk within the flood bank protection area, the responsible precautionary approach for us is to use a blanket avoid response to new development in that area until such time as the more refined information becomes available as planning maps.
And what that question highlights, I think, is the question that I have put earlier today. We know what the long-term answer is likely to be once we have the information across the whole of the catchment. And the question is, what do we do in the interim? Yeah. So what's your view in terms of what we should do while we're waiting for this additional work to be done? What should be in our decision?
So you're in a position where we have an operative plan at the moment, and there's an informed process there, we heard earlier, where when resource consents come in, they are referred to Environment South and for comment. So the question is, what is that ES model output? What is the future use of that? Is that being used from this point onwards? And there was reference to LIMS and PIMS through the building consent process as well. So there is already an informal link there in terms of considering the impacts of weather on the significant risk within these different areas. The same would be true, although more formalised through the regulatory rule framework within the Section 42A recommendations by inserting that reference to contacting ES for further information in terms of those flood risk areas. It's a step closer to a more formalised approach. In the interim, I've been able to actually design a full policy and rule framework around a completed ES model for the entire catchment.
If I can just interject there, Maria, to what you were saying earlier about finished floor levels being a managed response rather than an avoid. So when we're looking at NH Rule 5 in terms of the 42A supplementary evidence version, which is construction of new buildings, including conversion of existing buildings for sensitive activities within the stop bank protection area. So this is sensitive activities within the centre of Gore, essentially. So at the moment, Brett's recommendation is that's restricted discretionary, but only provided you can meet that 0.5% AUP finished floor level. So while that is a managed response rather than a void, if you can't meet that and you'd be relying on the ES information to see if you could meet that to inform whatever that finished floor level is, that then bumps you up to non-complying, which to me does meet that RPS requirement where you're avoiding sensitive activities in significant risk areas.
But only
because you just physically can't, you won't be able to get consent unless you can essentially construct your way out of it.
But this is the absolute core of all my questions today, because what you've just described to me is exactly what I've understood, which is that the avoid response is dependent upon whether or not you have adopted the management response, and I do not think that is the legal test that we have to apply.
But the other test is, what is the scope of the submissions? And that's something that we will need to work through. So what I'm hearing is that, and people keep referring to the regional policy statement, policy NH5, but on my copy it's NH4, and that talks about in managing natural hazards, the following implementation priorities are to be adopted. Number one, avoid exposure to areas at significant risk from natural hazards where practicable by adopting a precautionary approach. Number 2, mitigate, and number 3, undertake physical works. But in terms of clause 1, avoid exposure to areas of significant risk, that applies to, I guess, some of the questions that have come from Maria are, we've identified areas in the plan subject to inundation, and how we deal with significant risk, and that is one set of circumstances. But there's also areas outside of what's shown as prone to flooding, where there is also likely to be a significant risk. And in terms of the submissions that we have, I don't think it's within the bounds of what we can look at present for areas outside known flood areas to apply that. Notwithstanding, it will get picked up for subdivision. It will get picked up as part of building consent processes and limbs. But we can't include rules in the district plan for outside of the areas shown in the plan as notified. So that's my understanding of where we've got to. But it's still leaving up in the air the issue of, is it appropriate for us to define the term significant risk? And the advice that I'm hearing is, given that the categories, the 6 categories, have to some extent been identified, it may be open to us, but is there a submission we can rely upon that actually justifies it? So I'm really interested in getting a firm view from our advisors in terms of how far can we go in dealing with significant risk in our decision.
Brett, do you want to pick that up in terms of how you're or Mishka, in terms of how you've addressed it in the minute to 43 response?
I was just about to suggest Brett did address I think the Southland District Council submission on within this 42A. I think Brett, you were talking about that earlier. Maybe you could direct the council to that.
So there is, sorry, just checking my notes. If we, paragraph 77 to 81 address the issue of risk levels or hazard risk.
Which document? Sorry, which document are you referring to?
The section 42A report.
Can you just hold on until I bring it up? We've got so many different things to look at here.
No, I appreciate that.
So paragraph 77 talks about specific levels of risk.
Yeah, and it was in relation to Southland District Council's submission, which sought to have hazard risk levels that mapped in with the proposed NPS for natural hazard decision making. So they didn't ask for significant risk; they just asked for hazard risks.
So how does that bring us back to my question of, in terms of how we deal with significant risk?
Well, that is the only submission out of all submissions we received that made any reference to hazard risk, and it was in relation to the NPS NHD, and work through that in terms of why I didn't pick that up, but I did pick up the other side, which talked to hazard-sensitive development, and that was introduced through the policies and within the rules. But significant risk itself, there was no request for definition on that, and really we've developed that in response to Minute 43. And in doing that, I've taken reference from recent proposed district plan definitions and current best practice that is evolving at the moment. And we also took advice from Tonkin and Taylor, who assisted with presenting a clear and precise definition that could be worked through. So hence the 3 bullet points in there. And they are derived from the Australian Institute of Disaster Relief, which uses a table to use the combined amount and then the depth and the speed as maximum thresholds. So that's why those 3 bullet points are in there.
Okay, so you came up with a definition because we asked you to, but your advice is that we shouldn't be using it.
Well, I think the collective advice to you is there are challenges to it, and I think that's, I think Shelley has outlined those.
That was almost a political response. Is it your advice we should not be using it?
My advice would be that, of course, it's more helpful to have a definition. And if we were at the start of the process, I would certainly be drafting one. And I would certainly be using a comprehensive mapping base that used the ES flood maps over the entire catchment. But the challenge here is that in introducing it and running it through a sensitivities filter, you end up having to make substantial changes to your policy and activity statuses. And the implication there is around scope in terms of the degree of change. And we did outline one of those just as an example within the response to Minute 43. So that's a long-winded way of saying you could, but there's a couple of pretty clear challenges.
Yeah, I'm not asking what we could do. I'm asking what is your advice, and given all those qualifications, I'd probably interpret it this way: in an ideal world, or when a variation is prepared, it would be good to include all this stuff. But given the scope issues, given other issues that are identified in the supplementary report, you're not recommending that we do it at this stage. Is that a fair summary?
Yes, because it doesn't deal with the balance outside that yes.
A simple yes will do, thank you. We don't need it qualified any further, unless there's any questions arising. Maria?
Okay, so I'm going to ask one final question. Before I ask the question, I'm going to outline for you what my thinking is at the moment. From what I've understood, if I accept the case that's put to us by legal counsel and by yourselves, that we cannot use the maps and we cannot apply a definition of significant risk, despite expert evidence that we could infer significant risk from. Because we've got the inundation maps and we've got advice from Tonkin and Taylor and ES that within those potential inundation areas, there is a combination of areas of significant risk and areas of lower risk. But we cannot differentiate that through this planning process because we cannot use the definition of significant risk, all those maps. The precautionary response to that is to avoid new development in those areas as a blanket until such time as a new variation in plan change is promulgated. The only alternative to that I can see that would be appropriate in terms of giving effect to the RPS is to say this is a non-complying status for new development in these areas unless a resource consent applicant can demonstrate that they are not in an area of significant risk using that definition, i.e. the onus is put on the resource consent applicant to say that they've got an alternative pathway available to them. And so the default would be non-complying within the potential inundation area, but they could use the significant risk definition, understanding that you're not suggesting we use it in any other way, but if we use it in this way, then that avenue would be open to a resource consent applicant to then achieve the restricted discretionary pathway. I'm turning it round. You've given us a restricted discretionary default that goes to non-complying that I don't think we can use. And I'm suggesting to you that actually it would be more appropriate, precautionary, to default to the non-complying and then provide a pathway to achieve the restricted discretionary. Could you provide a response to that?
Yes, can. It's obviously a very hard conservative line to take because there will be properties within that area that aren't significant risk, and if they can't demonstrate that.
But we know they could, and this is the thing, we know they could because there is best available information that they can just put their hand on by going to the EES maps if they happen to be in the Goroha-Mataura area, that they could immediately pick up to demonstrate and achieve the restricted discretionary pathway. And in a very short space of time, they'd be able to do exactly the same thing outside of Goroha-Mataura.
So how would that map into the rule? How would that be addressed?
It would go like this. Well, I guess I haven't done it in the rule frame, like the wording of the rule. I'm just telling you that I think it should be this way around. The default is non-complying within the potential inundation area unless an applicant can demonstrate that using that significant risk definition without the note, that they are not in an area of significant risk. And in making a decision to take that approach, we know that there is best available information that would enable them to achieve that pathway by picking up recent modelling from ES, but we cannot utilise that and those planning maps in this process. But this is an alternative means to enable them to access the restricted discretionary activity that you're intending for them. But we cannot allow that restricted discretionary pathway for the significant risk areas that we know exist in the potential inundation areas. I don't think that's a lawful option for us.
Just tease us out a bit more, because as I understand it, what we're proposing is, in terms of avoiding risk, we're talking about risk to sensitive activities as opposed to non-sensitive activities, so there's that distinction. And there's also trying to avoid the risk by having a floor level above 0.5, the 0.5 AEP. So what I'm hearing you say is
that's a
not
management
an
response.
option.
That's a management response, not an avoid response. So I'm okay with reliance on minimum floor levels, guided actually by what I read in the RPS as well, that minimum floor levels are a management response, not an avoid response. So they are appropriate in the areas that are not significant risk, I would say, but I don't think that's the right step through to get to avoid.
So what about if you're avoiding a sensitive activity, such as a residential living room or bedrooms, by putting them above the 0.5% AEP, and so you've only got non-sensitive activities, a garage or a laundry or something within that risk area? Is that avoiding or is that mitigating in your mind? Because in the central city, for example, you can only do retail at ground level. You can't do residential.
Just a reminder, it's our job to ask the questions, not to cross-examine the
Yeah, I'm
panel.
just trying to clarify the question.
I know.
Yeah.
So I think what we have had is advice that what we're trying to do, to me that would be the kind of scenario that if you were in a non-complying setting, you could argue for. To me that's the appropriate place for that to happen. I think what I'm signalling is that I think the direction is needs turning around. You're coming at it from the well, it's not sitting right from what I've read and understood of the expert evidence. The expert evidence to us is that if you're in the significant risk areas, a minimum floor level is not the right response. The right response is to avoid development in those areas. And so I guess I'm looking for the planning response that matches the expert evidence we've received.
And we've had a response to that in terms of sitting with what's been recommended. I doubt we can take it any further with our advisors.
Unless there was some willingness to explore the option that I just put forward, which is to start with a non-compliant default and then make available a restricted discretionary pathway based on a significant risk definition.
But you can't, well, I'm interested in the legal response to having non-complying that would trigger to a restricted discretionary.
Well, for me, what that puts a question up is, if I'm looking at it from a bottom-up perspective, which we talked about earlier, is the change from the notified status would need to be clearly signalled in submissions. And for me, it would also need explicit wording to say non-complying on this site, so that the relevant landowner could appreciate the extent of impact on their particular property and then decide whether to engage with the process as a result. And that includes, for example, areas where no development might be the appropriate precautionary response, but giving a landowner time to process that extent of regulatory change and be involved in the process, which creates that new restriction on them. That's where and I appreciate all of your concerns around the new information that you've read, but that's where I'm coming from in terms of saying we need to draw a line on what information is engaged with.
Would that risk to the person who hasn't been involved in this process be reduced if a restricted discretionary pathway was made available?
Mishka, what do you say to that question?
Sorry, I couldn't actually hear the question. Can you repeat it?
Would the risk you?
No.
I think maybe just a bit closer.
Would the risk to someone who has not been part of this process be reduced if a pathway was made available for a restricted discretionary activity?
So do you mean risk in terms of scope or risk to flood risk?
Risk in terms of scope, which is what legal counsel was signalling about. Yep.
Can you just give us a steer on appreciating the planning change or the extent of shift from the notified version plus submissions in terms of restricted discretionary?
Brett might be the best place to talk about the change from that. Certainly going to non-complying would be a big jump.
It would be a big jump. I mean, at the moment, yes, its starting point is restricted discretionary, the sensitive activities in the stock bank protection area.
That started off being permitted under the notified plan, provided they could meet that.
There was no, under the notified plan, there was no relevant hazard provisions in the stock bank protection area.
So if we accepted the Environment Southland submission at the objective and policy level to avoid significant risk and manage other risk, which was obviously a very clear signal and direction.
Yeah, so, well, what you're suggesting is splitting that rule into sensitive activities within, say, the stop bank protection area, into a restricted discretionary where you are H1 to H3, if I understand that correctly, and you would mitigate with a finished floor level, but it would elevate to non-complying if you were over and above that.
Yeah, I guess that way round. Yep.
Yep, and I'm also mindful of the submission that Environment Southland lodged to Objective 4. And while the words start off by saying clarifications needed about whether this objective is permissive it was to Objective 3, provide for the avoidance of development where there's a significant risk from natural hazards as required by the regional policy statement. It goes on to say this links to other submission points about zoning new land for intensification of development, which brings into play what would a person reasonably expect the outcome to be on looking at it as a whole. And to me, it actually limits the way that we can apply that submission. So I guess we've kind of talked around that point in some details. Mishka and Brett, are there other points that you think need to be raised from what's been talked about earlier this morning and the material that you've sent in?
Nothing from me.
No, nothing from me.
Mishka, I was confused by, in paragraph 18 of your supplementary statement, in referring to the areas of disagreement, you said that issues of scope remain with either return period. Why is there an issue of scope over the 0.5% return period?
That was more if you were to introduce the maps. That was my issue of scope. I'm not suggesting there's an issue of scope in terms of the 0.5 being incorporated into the plan, because that was what was notified. But if you were to introduce the 0.5 AEP maps, that's what I'm suggesting is an issue of scope.
Right. Okay, any other questions from the panel? Because I'd like to give Marcus an opportunity if we've kind of talked about him for the last little while, and Shelley's got something to say first.
Sorry, just a little tidy up. We were talking about activity classifications and obtaining information from ES. Just wanted to tidy up when I got my words tripped up and I was talking about objections. For a permitted activity, you can of course obtain a certificate of compliance, and then that process has the ability to interrogate the expert information through that process if it was something that you were considering in terms of how you would engage with the ES information for permitted activities.
So Marcus, you've heard us talking about you and what's in the ES submissions. So is there anything arising from that you want to respond to?
I think we're probably getting close. We're probably getting close to having done it to death, to be fair. I think, it's a tricky position, as Brett sort of outlined the panel find itself in. I also found our submission point on objective natural hazard, objective 3, which you've already read out, Commissioner Havel. Effectively I haven't got too much more to add to where we're at the moment, but yeah, very salient point Commissioner Bartlett's raised around that avoidance first mitigation policy for the stop bank protection area. That was effectively the thrust of our submission, is trying to get that that precautionary approach where we need to avoid and manage where the risk is less than significant.
Okay, anything else from the panel? Smiles all around. So that then brings us to end of consideration of issues on natural hazards. Marcus, you've done a few journeys to us over the time, and it's become more complex as we've gone through time. But thank you for your best efforts in terms of trying to help us through the process, and we've got a lot more talking to do amongst ourselves yet. So thank you for hanging around today, and if there's anything else, I think we've really got to just reach a view ourselves and do the best that we can.
No worries, thank you. It's just a shame we didn't have the fulsome mapping of the whole district at the time the plan was notified, but we are where we are.
So the time is now 12:26, and it's probably a good time to stop, because 12:30 it says on my timetable lunch, followed at 1:30 by Paul Johnston and Robin Miller. So we will adjourn until 1:30. Thank you.